Ladies and gentlemen, the Chief Justice is Paul Turner. He is a Justice of the California Court of Appeal. You are the presiding Justice of the 5th Division, is that right?
Right, of the 2nd Appellate District.
2nd Appellate District of Los Angeles. To his left is his colleague, Justice Lamar Baker, also on the 5th Division, California Court of Appeal. To the far left is Judge Laesecke of the Long Beach Superior Court. To Chief Justice Turner's right is John Tobin. He is a federal judge. So you have Judge Tobin. Over here is, if I'm not mistaken, the only father-son pair to serve on the California Court of Appeal.
There have been two.
There have been two. Well, this is one of them. That's not here. So we have Justice Gary Hastings, retired Justice of the California Court of Appeal. So 3 Court of Appeal justices, federal judge, trial judge. Okay? Petitioner, Respondent. Mr. Chief Justice, it's in your hands.
Fine, you may be seated. Before we begin, we want to make sure we have the names of the finalists correct. So I'm going to ask, first of all, from Team 114, who is going to argue first? And if you could just stand and give us your name.
I will be arguing first, Your Honor. My name is Caleb Engel.
Just a moment, Mr. Engel. Give us a second while we write this down, okay? We have to get this right. Okay. And the second advocate?
Your Honor, my name is Christopher Baldacci. I will be arguing second.
Just a moment, Mr. Baldacci. All right, now, if we need to do the same thing with the respondents, which are Team 102. Who's going to be arguing first?
Good evening, Your Honor. My name is Ashlyn Olson, and I will be representing the respondent on the First Amendment issue.
All right, Ms. Olson, thank you. And then Mr. Ness, Jacob Ness?
That's correct, Your Honor. I will be speaking second.
Okay, one other, I guess we call it housekeeping. Is there going to be any time reserved by the petitioners?
Yes, Your Honor. We would like to respectfully request to reserve 3 minutes for rebuttal.
All right, Mr. Engel, there'll be 3 minutes will be reserved for rebuttal. All right, let me call the case as we do in real courts. And after I call the case, we'll commence with the arguments. All right, this is Kadesh College et al. Versus the United States of America. It is case 2015-2016. And we're going to begin the arguments on behalf of petitioners. We're going to hear first of all from Mr. Engel. Mr. Engel, you may approach the lectern and commence your argument, sir.
Mr. Chief Justice, and may it please the Court, my name is Caleb Engel, and I, together with my co-counsel, Christopher Baldacci, represent the petitioners in the case at bar. I will be representing Kadesh College in its First Amendment claim, and my co-counsel will represent Ms. ARH in her Fifth Amendment claim. The Fair Education Act is an unreasonable attempt on the part of Congress to regulate immigration at the expense of a private college's free exercise rights. And for that reason, we ask this Court to declare the law unconstitutional. To this end, we offer 2 points of argumentation. First, we ask this Court to overturn its decision in Employment Division v. Smith and apply the compelling interest test, as it did in previous free exercise cases. Second, we address the government's asserted interests in the Fair Education Act and contend that none of these interests rise to the high standard this Court has established for the compelling interest test. Addressing the first issue. Your Honors, this...
What is the religious basis of the college's First Amendment claim? Is it the language in Psalms 5, 11, and 12?
Your Honor, as we find on page 5, paragraph 2, that is part of the college's religious claim.
Well, I've looked at this, and it doesn't say anything about immigration, immigrants, naturalization, or education. It's certainly moving and beautifully written scripture, but it doesn't talk to that issue. How can we conclude that there's a religious component to your claim in light of the language which appears in Psalms 5, 11, and 12?
Because, Your Honor, as we find on page 6, paragraph 3 of the facts of the record, Kadesh College's founding document mandates that it provide at least one scholarship every year.
If we can just go back, though, to the language in Psalms 5, 11, and 12. where is it, or what's the logical connection here between an immigration and naturalization policy and the language which is in our record, which is relied upon by your client as a scriptural basis for their conduct in this case?
Your Honor, Kadesh College's religious foundations are not solely found in the Psalm, although that is their school motto. Rather, the school draws the foundation for its ministry to immigrants, undocumented persons, and just generally persecuted persons from the principle of the biblical city of Kadesh, which is a safe haven for exactly these types of people. Now, Kadesh College believes it has a specific ministry towards undocumented persons as outlined in its founding document.
Counsel, if I may, although that is a wonderful sentiment, what precedents from this court have defined what a religious institution is or what it must be in order to claim the protections that Kadesh is claiming?
Your Honor, this court in the case of Hobby versus Unemployment Appeals Division of Florida, as cited in Smith, articulated the standard for a substantial burden on religious exercise. And they stated that you must demonstrate that there is a substantial burden on religious exercise. And we find the specific standards for that in the case of Locke versus Davia, cited in footnote 16 of Parker versus Hurley, wherein this court stated that there's no burden on free exercise if the state has not instituted a civil or criminal prohibition on any type of religious act or rite.
How many undocumented immigrants does your client have to admit, such as to, at least in your view, establish that there is no substantial burden on its religious exercise? Is one student enough?
Your Honor, Kadesh College doesn't necessarily differentiate based on the specific number, but rather what they feel is their burden towards any particular one. As we find on page 5, paragraph 3 of the facts of the record, Kadesh's president, Bobby Bronner, considers the statement of faith essay, which all applicants must write, as the most essential part of their application, implying that Kadesh College's ministry is focused on highly individualized assessments, whereby Kadesh determines whether or not the specific undocumented person in question is the one they feel most burdened to minister towards in the exercise of their religion.
Is it your position this is a hybrid case?
No, Your Honor, which is why we asked this court to overturn its precedent in Employment Division versus Smith. This country was founded on the balancing of both the principle of the common good and living under the dictates of the law, but also on valuing individuality and the right of everyone to live according to the dictates of their own conscience. And that's why this court in the case of United States versus Ballard, as cited in Smith, stated that our Constitution was crafted to give the widest deference to the array of religious beliefs which arise in a society so diverse as ours. However, in the case of Employment Division versus Smith, when this court ruled that in the face of a law of neutral and general applicability, the free exercise clause alone was not sufficient to trigger strict scrutiny, it repudiated this court's precedent and the principle that the free exercise clause is one of the most fundamental rights which we as Americans can enjoy.
If the college believed as part of its religion that that all of its students should use marijuana once a day, and Smith is no longer on the books, how would we review that sort of a claim?
Your Honor, that claim would be reviewed under the compelling interest test, which, as Justice Blackmun stated in his dissent in Employment Division versus Smith, strikes the balance where it preserves the First Amendment's mandate of preserving religious liberty to the fullest extent possible.
So your view is we have to apply the most demanding test known to constitutional law if your clients assert it's their religious belief that students should use marijuana once a day?
Yes, Your Honor, because that's consistent with this court's precedent, where there is a demonstratedly sincere religious belief that is substantially burdened by a law in question, the compelling interest test is appropriate.
So your position is that you would use the compelling interest test to permit the use of marijuana by college students, by teenage college students. Is that your position?
No, Your Honor, that's not our position. We believe that just as Justice O'Connor found in her concurrence, that drug use by a religious organization would fail the compelling interest test. And that's why the compelling interest test is appropriate, because it strikes a reasonable balance between the right to free exercise and the government mandate to uphold the laws.
How is this a substantial burden on Kadesh?
Your Honor, as already discussed, Kadesh College believes that it has a religiously motivated mission to minister to very specific undocumented persons. And the Fair Education Act, even though tailored through DACA, prohibits Kadesh College from doing so, which is a substantial burden of the highest order.
We only have one student at issue here, don't we?
Your Honor, as far as page 6, paragraph 3 of the facts of the record indicate, Kadesh must provide a scholarship to at least one undocumented student per year. However, as already articulated, Kadesh does not believe its religious mission is solely based on numbers, but rather on its ability to minister to these needy persons. Now, addressing the government's assertion...
Isn't there a difference, though, between the marijuana issue and the peyote issue? Is that in terms of peyote, there's not the evidence that exists in terms of its deleterious effects as might exist in terms of use of intoxicants by teenagers.
Yes, Your Honor, and that's why the case of marijuana would fail the compelling interest test even more surely than the use of peyote would, which means that there will be no issue in that instance from applying the compelling interest test. As far as the government's interest...
Is there any other reason we should reject Justice Scalia's analysis?
Yes, Your Honor. Not only does it denigrate the right to free exercise, but it's also inconsistent with this court's precedent in the case of Thomas versus Unemployment Review Division of Indiana, Hobby versus Unemployment Review Board of Florida, Hernandez versus Commissioner, Wisconsin versus Yoder, Sherbert versus Verner, McDaniel versus Patty, and other precedent as cited in Smith. To uphold the principles of constitutionality, which this court has in its previous jurisprudence, and the very principles on which our country was founded, this court ought to overturn the Smith decision and declare the Fair Education Act unconstitutional.
Thank you very much, Mr. Engel. Mr. Baldacci? You can commit your argument, sir.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Christopher Baldacci, and I rise to represent the petitioner, Ms. ARH, on her Fifth Amendment claim. The Fair Education Act and DACA disadvantage Ms. ARH and similarly situated immigrants for the sins of their parents, which is not only fundamentally unjust, but a violation of her equal protection rights enshrined in the Fifth Amendment of the Constitution. To this end, we offer two arguments. First, that the unique discriminatory nature of the law demands that the government provide a substantial interest. And second, there is no interest in keeping young immigrants such as Ms. ARH out of college. To the first argument.
Let me anticipate a bit of your argument. Are you going to rely on Plyer?
Certainly, Your Honor.
Is there anything in Plyer that would preclude or impair the ability of the federal government to deport any of the elementary school students in the state of Texas at the time of the Plyer case?
No, Your Honor.
Then what discriminatory conduct is the Fair Education Act imposing on an individual who is eligible for deportation?
Your Honor, the federal government has the full authority to deport any immigrant that it sees should not be in the United States. However, this court has held that as long as an undocumented person is residing within the boundaries of the United States, they have just as much equal protection rights as any other citizen.
That's a circular argument. The individual is here without benefit of the sovereign's consent. If they are here without benefit of the sovereign's consent, any other laws that are premised upon the lack of consent of the sovereign, how can that be a discriminatory burden?
Your Honor, regardless of whether or not they're here without the federal government's consent, this court held in Wing Wong versus McGrath and Wong Ying Sung versus the United States, as cited in Matthews versus Diaz, that regardless of how aliens came here, they're protected by the Equal Protection Clause as long as they reside in this country. And the federal government may have the authority, and does have the authority, to deport them as they wish.
But in those cases, didn't the issue turn on the receipt of federal benefits? In this case, we're not talking about federal benefits, we're talking about controlling immigration.
Your Honor, in Matthews versus Diaz, it was dealing with the provision of governmental benefits. However, the cases cited within Matthews talking about the equal protection rights of non-citizens were universal. And that's the basis for the arguments that Ms. ARH deserves the equal protection, the rights of the Equal Protection Clause.
Is public education a right under the federal Constitution?
No, Your Honor. In San Antonio Independent School District versus Rodriguez, this court held that education at any level wasn't a fundamental right. However, in Sherbert versus Verner, as cited in Plyler versus Doe, this court recognized that discrimination doesn't turn on whether or not something is a constitutional right or simply a privilege of being in this country. And in Plyler versus Doe, we believe the standard that they applied of intermediate scrutiny to the law in Texas should also apply in this case.
Wasn't part of that as a result of the fact that the state was standing in loco parentis to individuals who were minors, and that the deprivation to minors of the basic skills of reading and writing would cause them to be burdened, significantly burdened. And that indeed might have been the burden in the prior case. Here, we have an individual who has reaped all those benefits. Well done, Miss ARH. But under prior, the benefit that those students were being denied has been obtained here. Why is Plyler even applicable?
Certainly, Your Honor. Yes, Plyler versus Doe was dealing with primary education and illiteracy. However, the principles of Plyler also apply to Miss ARH. In Weber versus Aetna Casualty and Surety Corporation, as cited in Plyler, this court held that it was unjust and unconstitutional to punish a child for the sins of their parents. And as we learn on page 7, paragraph 1 of the record, Miss ARH was brought into this country when she was 6 months old by her parents. She had no control over the undocumented status that now keeps her out of college.
But the federal government can still deport her.
Certainly, Your Honor.
Then I don't see where you're going.
Certainly, just because the federal government has the authority to deport her doesn't mean that while she continuously resides in this country and is not being deported by the federal government has the authority to unjustly discriminate against her.
How is she being discriminated? This is not a federal education she's being deprived of.
Yes, Your Honor. In Plyler versus Doe, this court articulated that the core purpose of the Equal Protection Clause was the abolition of government barriers presenting unreasonable obstacles to advancement based on individual merit, which is exactly what's happening to Miss ARH. She's unavailable to avail herself of the opportunity of post-secondary education that millions of other citizens can take advantage of with the same quote-unquote criminal record as Miss ARH and the same absences from the country as Miss ARH.
Is she actually being denied an education, or is it just being delayed? If she went through the proper steps and the proper channels, she could get that education at a later time. Is she actually being denied anything?
Your Honor, she is currently being denied education. There's no facts in the record given to indicate whether or not she would be able to apply for legal residency or apply for citizenship, or even if she would pass those standards given that she failed the DACA requirements that the federal government set forth. And this court has never considered the fact that just because a person down the road could potentially change their status, that the current denial of an opportunity wasn't enough to make a constitutional adjudication. This was actually the case in Matthews versus Diaz, where the court ruled on those refugees who could potentially have sought administrative remedies, but the facial denial of them to be able to take advantage of welfare benefits was enough to rule constitutionally.
Go ahead, please.
Please.
No, please, go ahead. I dare you.
Is the status of Ms. ARH immutable?
No, Your Honor, which is one of the reasons why strict scrutiny wouldn't be appropriate in this case.
So I'm left confused. I don't understand what your argument is for heightened scrutiny. You concede that there's no fundamental right at issue. You concede that there's no suspect class at issue. What possible reason would we have, and I take it your response is going to be, well, Plyler applied something, and this case is sort of like that. But I need more than that. I need a doctrinal basis on which we would say heightened scrutiny is appropriate in this case, and I'm wondering if you can give that to us.
Absolutely, and I would direct your attention back to the Plyler, but to the doctrinal basis for which Plyler applied intermediate scrutiny. Plyler recognized that there was no fundamental right at stake and they weren't a suspect class, but raised the level of scrutiny because some laws on the federal government's part, while not facially invidious, can still violate the principles of equal protection, which they define in footnote 14 to be laws which disadvantage groups of people based off of circumstances that they couldn't control. And Miss ARH is disadvantaged from being able to go to college because her parents brought her into this country while she was an infant. And that type of discrimination is repugnant to the principles of equal protection.
Can't she take steps to have herself treated as a documented alien, properly documented alien?
Your Honor, again, there's no facts in the record to indicate whether or not what steps she could take, and neither DACA nor the Fair Education Act offer opportunities to Ms. ARH to avail herself of opportunities to become.
But in footnote 14, which you cite, it says classifications treated as suspect tend to be irrelevant to any proper legislative goal. Certainly, a proper legislative goal would include making certain that there are sufficient spots available in private and public institutions of higher education. And here, a spot has been taken by somebody who is not in this country lawfully. Based on that language in footnote 14, isn't that sufficient to permit the government to prevail on this issue?
Yes, Your Honor, and that turns us to the interest and whether or not the government has a substantial interest at all. And to the contrary, in Employment Board versus Fernandez de Otero, as cited in Plyler, this court held that a simple intention to discriminate is not enough of a basis for the government to have to justify a law. And simply saying that they're intending to save college slots for citizens and not give them to undocumented persons isn't enough to justify their legislation. They have to show some interest in denying undocumented persons the ability to go to college, and there simply is none. As my
There's no incentive to gain citizenship. There's no preservation of resources.
Your Honor, as my co-counsel articulated, this court has routinely struck down the idea that the preservation of resources can justify discrimination in cases such as Shapiro versus Thompson and Takahashi versus Fish and Game Commission, as cited in Graham versus Richardson. Additionally, this law doesn't incentivize legal immigration or legal residency. It simply punishes those who are here because of the actions of their parents. And for this reason, it's unconstitutional. Thank you.
Thank you very much, Mr. Baldacci. We'll now hear from Ms. Olson. Ms. Olson, you may approach the lectern and commence your argument.
Thank you, Your Honor. Mr. Chief Justice, and may it please the court. My name is Ashlyn Olson, and together with my co-counsel Jacob Van Ness, we represent the respondent, the United States of America. I will be addressing the First Amendment issue, and my co-counsel will be addressing the Fifth Amendment issue. We ask this court to rule that the Fair Education Act does not violate the First Amendment for two reasons. First, there is no substantial burden being placed upon Kadesh College's free exercise of religion. And second, the government has both a rational as well as compelling interest in preserving the rule of law. Before specifically addressing how Kadesh College's free exercise of religion has not been substantially burdened, I would like to address Petitioner's request for this court to overturn the long-standing precedent in Employment Division versus Smith. If this court were to overturn its decision in Smith, it would be overturning decades of this court's precedent, starting in Reynolds versus United States, moving to Bowen versus Roy, touching on in Lee versus Northwest Indian Cemetery.
What if we were wrong then?
Your Honor, this court is asked to look at all of the previous precedent to determine whether or not there was a true deviation in Smith from the precedent that this court has already laid out. Specifically, this court has warned itself in Ashwander versus TVA, cited in Grace United versus City of Cheyenne, that if the court were to make such a broad and sweeping decision, such as overturning a long-standing precedent such as Smith, the court would have to very carefully examine all of the prior precedent. And in the very limited record that this court has been presented for today, it would be a dangerous assumption for this court to deviate from the majority in Smith that already found that in cases such as Murdoch versus Pennsylvania or even Cantwell versus Connecticut, that what Smith was doing was saying that in neutral laws of generally applicable cases, we cannot have free exercise claims in a vacuum. You see, yourself, Justice Baker, pointed out in questioning to opposing counsel that if we were to overturn the decision in Smith, we would run the risk that the court talked about in Reynolds of a man becoming a law unto of himself and being able to make decisions simply because he claims that it is religious exercise.
Right, but on the other hand, we also have, I think, a fairly strong tradition of not questioning the religious claims made by people or an organization. And if we accept your argument, don't we in some way have to take issue with the college's claim that part of what their religious belief is, part of what their religious mission is to minister or to engage with undocumented immigrants in this case?
No, Your Honor. In fact, we have already stipulated that we do believe Kadesh College has a sincere belief, and that's exactly why we should preserve the Smith precedent. You see, if we remove Smith, we must revert back to the Sherbert versus Werner test, which actually places the court as the sole arbiter of determining whether or not there is a sincerely held religious belief. What Smith tried to do was to strike a balance between what the court had already established in Reynolds and what the court had decided in Sherbert versus Werner, to say that when there are cases of the free exercise of religion, we do want to grant deference to those religious beliefs, but we also want another secondary right to ensure that the violations are actually substantial enough for this court to reach it to the level.
Why is this not substantial?
Your Honor, the very reason is what Chief Justice Turner addressed, that the very mission statement of Kadesh College and even the verses that it cites never specifically mentions undocumented persons. In fact, the only time we see Kadesh College even mention undocumented persons in their founding documents is the one scholarship that can be designated to
So
undocumented.
you're suggesting this is not a sincere religious belief of theirs?
No, Your Honor. We do believe that it is a sincere belief, but it is not being substantially burdened under this court's precedent in Hernandez versus Commissioner, as cited in Parker versus Hurley. You see, in order for there to be a substantial burden, we would be having to require Kadesh College to fundamentally alter how it exercises its religious belief, when in fact, according to page 3 of the record, the only students that DACA, or the Deferred Action for Childhood Arrivals, prevents from attending Kadesh College or any other institution are undocumented persons with criminal records.
So are you suggesting then that this is a de minimis impairment and based on the numbers in the Kadesh case versus those on a national basis, and that it satisfies the rational basis test?
Yes, Your Honor. Not only is it based on numbers, but it's also based on the precedent that in no way, shape, or form is the Fair Education Act asking Kadesh College to change its religious mission, to change its teachings, or to any way alter the way the school fundamentally acts
So
in its current state.
I'm a little confused. Would you agree that at least their belief is that in order to exercise their religion, they have to admit undocumented immigrants into their school? Do you agree that that's their religious belief?
Yes, Your Honor.
And you don't question that belief?
No, we do not question that.
And the law prohibits them from admitting undocumented students into their college. That seems like a substantial burden to me.
Not exactly, Your Honor. Respectfully, according to page 3 of the record, which states that if a university is seen as in compliance with DACA, it's also seen as in compliance with the Fair Education Act. The only undocumented students that are being prevented from attending Kadesh College are those with a criminal record. And at that point, whether or not the court decides to apply a rational basis test or a compelling interest test, the government does have a valid reason to be able to draw that very clear and small line to restrict Kadesh College from accepting those particular individuals.
Let me ask you a different question then. Let's say 4 years from now, the executive branch rescinds what is now DACA and institutes a different policy with different procedures. Is your argument that somehow the constitutionality of a federal statute depends on the whim of the executive?
No, Your Honor. Footnote 2 on page 3 of the record states that the constitutionality of whether or not the executive can create something like DACA is being under consideration by another court in a different case proceeding. Yet the record that we have before this court is functioning under the assumption that the Fair Education Act isn't seen in conjunction with DACA, and thus that's not a question before this court today. What DACA and the Fair Education Act do is promote the governmental interest of preserving the rule of law. If this court were to uphold its decision in Smith, Petitioner has not presented a valid hybrid rights claim since they have only argued the free exercise of religion.
Do you believe that we should use a hybrid rights theory?
Yes, Your Honor. That would be consistent with this court's precedent in Employment Division versus...
Let me ask you this. Based on our record, it's clear, there's nothing in our record which indicates that when the amendments to the Constitution or the provisions of the Constitution were adopted or in the process which led up to them, that there was any discussion by those involved in that process that there would be a hybrid rights analysis. In addition to that, I think you'd agree with me, there's two words that don't appear in the Constitution of the United States or any of its amendments, and those two words are hybrid rights. Shouldn't we reconsider the position that we took vis-a-vis hybrid rights that we took in the Employment Division, Department of Human Resources of Oregon? Shouldn't we reconsider that in light of the fact there's no either textual basis for such a theory, nor is there any historic basis for a theory if there's any ambiguity in the language of the Constitution?
Chief Justice Turner, as a respondent, we are asking this court to remain consistent with the precedent.
I'm good with that. I understand that argument. My argument's different. Why weren't we wrong in Justice Scalia's opinion when he adopts essentially a hybrid rights analysis, given the fact that it's not in the Constitution, all right, nor is it is there any evidence in our record of it being involved in the adoption of any provision of the Constitution or an amendment that is at issue in this case? That's my question.
Yes, Your Honor. Specifically, Your Honor, because what Smith accounted for was that in cases of free exercise of religion, regardless of whether or not hybrid rights had been previously discussed by the court, that they wanted to create a paradigm or a metric, like this court frequently does by creating the rational basis test or the compelling interest test, to be able to adequately weigh cases regarding the free exercise of religion so that they aren't made in a vacuum. But even if this court were to overturn its decision in Smith and apply the strict scrutiny standard, this court could still consider the valid and in fact compelling reason for the Fair Education Act, and that's upholding the rule of law. You see, under the Fair Education Act and even under DACA, this court is remaining consistent with its ruling in Matthews versus Diaz that says that the government is allowed to draw lines based on character and duration of residency in order to uphold their interests of both incentivizing legal immigration and discouraging illegal immigration. And that's exactly what the government is seeking to do through the Fair Education Act in today's case. The requirements laid out in DACA specifically target undocumented persons with multiple misdemeanors and felonies, or for individuals who have shown the financial capacity to travel in and outside of the United States, demonstrating that they do have the ability to find legal documentation within the United States, and that that's not a financial hindrance to them. You see, these valid interests of the government have already been upheld by the court, and they outweigh any sort of rights claim that petitioner can present before this court today. And because there has been no substantial burden on the free exercise of religion, and there is in fact a valid interest of the government being espoused by the Fair Education Act, we would ask this court to uphold this decision. Thank you, Your Honors.
Thank you, Ms. Olson. Mr. Van Ness. You may commence your argument, sir.
Mr. Chief Justice, and may it please the court. My name is Jacob Van Ness, and I represent the United States on the Fifth Amendment issue. We ask this court to affirm the decision of the lower court and hold that the Fair Education Act is not in violation of the Fifth Amendment for two reasons. First, DACA serves as a generous compromise on behalf of the government that seeks to address the plight of the children of undocumented persons while still advancing the national interest. And second, drawing lines based on character and duration of residency are unquestionably reasonable based on this court's precedent in Matthews versus Diaz. Before I get into my arguments, I would like to address the issue.
Is that the test reasonable?
Yes, Your Honor. It is our contention that the rational basis test is the appropriate standard of review, as has always been held by this court, in matters of immigration law and policy. If we look specifically to Matthews versus Diaz, the only case in our record that deals with federal policy towards undocumented persons, reviewing a law that the government made discriminating within the class of aliens, the government or this court applied rational basis review as acknowledged that the class of undocumented persons is one that is not constitutionally irrelevant. Similarly, while opposing counsel relies heavily on Plyler versus Doe, it is important to notice that there are three individually independent distinguishing factors why Plyler versus Doe should not be viewed as controlling. The first factor is that in Plyler versus Doe, this court was reviewing a statute that was a state law. The state of Texas was attempting to deprive the children of undocumented persons from receiving a public education. The court noted in footnote 4 of Plyler versus Doe that the lack of congressional authority linking education to immigration necessitated that the state of Texas did not have the standing to award them rational basis review. Instead, the court awarded intermediate scrutiny. The court further went on to clarify that if the state of Texas had been able to link education to immigration, then the case would have been decided differently. It is clear that because the state of Texas lacked the immigration mandate that Congress and the President do jointly, that was the reason that heightened scrutiny was applied. Whereas, in cases like Matthews versus Diaz and Graham versus Richardson, mere rational basis was applied. The second distinguishing factor, as you noted yourself, Your Honor, is that there are minor children regarding primary and secondary education within the state of Texas, which is distinguishable from this case, where we have Miss ARH, who is an adult, who has control over her status, and cannot claim that that status is a decision of her parents.
Let me take you back to the statement you just made about Plyler, and in particular, I'm looking at page 217 of the opinion, where it says, in addition, we recognize that certain forms of legislative classification, while not facially invidious, nonetheless give rise to recurring constitutional difficulties. In these limited circumstances, and the case goes on to say that we're going to apply heightened scrutiny. So it doesn't really seem to have anything to do with the difference between immigration or non-immigration. It seems like the court's language is give rise to recurring constitutional difficulties. And here we have a Plyler case that involved undocumented immigrants. We've got another case now that involves an equal protection claim involving undocumented immigrants. Isn't that the sort of recurring constitutional difficulty that should give rise to heightened scrutiny?
Your Honor, that statement by the court is very unclear in determining exactly what they're referring to. I would once again refer you to footnote 4, which states that if there was congressional authority, if Congress had linked education to immigration, then the court would have decided differently in the case of Plyler versus Doe. But more importantly, the issue is that the state was attempting to make classifications and make distinguishments in how they apply their law to the classification of aliens. What is noted in Plyler versus Doe is that the states have no power when it comes to the classification of aliens, and that distinguishing between how they treat different classes of aliens is not within their authority.
Is it your position that the Fair Education Act is indeed a response to Plyler, seeking to limit the expansion of the right of education by linking immigration and education as set forth in footnote 4?
No, Your Honor. Certainly because of the fact that Plyler versus Doe was decided in 1984 and that 30 years have passed without any change in the immigration law makes it clear that that's not Congress's intention. Rather, Congress's intention in the passage of the Fair Education Act is a reality that was acknowledged in Plyler versus Doe, which was that at that time, education was not a primary incentive for individuals to unlawfully reside within the United States. Certainly in the intervening years, higher education has become such an incentive, as is the case with Miss ARH.
What is the evidence for that?
The evidence exists insofar as the court cited Section 1324 of Title VIII in Arizona versus the United States, which states that undocumented persons are barred from employment within the United States and even penalizes American citizens for failing to verify the residency status of those they employ.
Employment is not education.
Yes, Your Honor. But the reasoning that the court has always allowed such a law to exist, and it's consistent with federal authority in the area of immigration law and policy, is because the employment of undocumented person acts as an incentive for them to continuously reside within the United States instead of attempting to change their status.
But by parity of reasoning, shouldn't we have said in Plyler that in order to endorse that goal of disincentivizing, we should have found to the contrary?
No, Your Honor, because in Plyler versus Doe, the court noted that that was not the interest of the state. The state of Texas has no interest in disincentivizing illegal immigration, which was further affirmed by the court in Arizona versus the United States. That when it comes to the states, they have no such mandate and they have no such authority to determine immigration law and policy. That is why the court decided that way.
Well, it seems like you're placing a fair amount of reliance on the fact that it's Congress acting and Congress has plenary power over immigration. And I'm just wondering if you can define what the limits of that power is. In other words, would it be permissible for Congress to enact a law that says every undocumented immigrant in the United States shall work as an indentured servant to somebody else who is a citizen for 2 months?
No, Your Honor. The precedent that we're relying on is that in Graham versus Richardson, where the court stated definitively that what is a privilege rather than a right may be made contingent even upon citizenship. Insofar as education is not a right, as many of the justices have noted and opposing counsels have conceded, education is a privilege and therefore may be made contingent based upon reasonable lines drawn by the government. This brings me to my second argument.
Could I ask you two quick questions? What do you say footnote 4 in Plyler says?
Footnote 4, I believe, Your Honor, states that because of the lack of the immigration authority of the state of Texas, that if they were able to point to a congressional law that links immigration and education, that the court likely would have decided the case differently. But specifically referring...
My second question is this, and this goes back to the immutable characteristic language in Plyler that you adverted to very briefly. Very quickly, my question is this. The point that I think that your colleague, Mr. Engel, would raise is that certainly there's an opportunity for her to become a citizen, to go through the naturalization process. The problem is he's contending that right now his client is entitled to attend this university. Isn't that different from the analysis concerning immutable characteristics which appears in Plyler?
Your Honor, it is different from the analysis regarding immutable characteristics. And similarly to the law that's always been upheld by this court regarding the barring of employment of undocumented persons, the same reasoning applies. The same argument that Your Honor is making.
His point is, my client's entitled right this instant under the due process, right this instant, under the due process clause, to have an opportunity to attend school now, and that has nothing to do with immutable characteristics. It has to do with now. What's wrong with that analysis?
Two problems, Your Honor. First, it would directly contravene the government's compelling interest in disincentivizing unlawful residency. By allowing Miss ARH now to attend college, that would mean that she would be able to attend college for the next 4 years in her unlawful status, when she is unwelcomed by the Federal Immigration Authority. As you yourself noted, she continues to be unwelcome in this country according to the sovereign. And thus, such an argument, allowing her to attend college now, directly contravenes this authority, directly contravenes this interest of the government. The lines that have been drawn by the government are extraordinarily reasonable, based that Miss ARH, because of her own individual circumstances, first because of her multiple misdemeanors on her record, and second because of her frequent travel outside the United States, is barred from attending college in her undocumented state. There is an incentive for her to seek documented status and thus no longer present the burden on the government that occurs when individuals who are residing in the United States continue to have an incentive to not seek lawful status.
Does the government have an obligation, therefore, to act more efficiently and precipitously in responding to those who make requests for legal status? Right now, the backlog on immigrations is significant. Is that her problem, or is that the government's problem?
Your Honor, I see that my time is about to end.
Go ahead and answer that question.
Your Honor, that is certainly not Miss ARH's problem. However, certainly the government would not invalidate the multitude of laws that are cited in Arizona that seek to disincentivize unlawful residency in the United States. Most specifically analogous to this case would be Section 1324 of Title VIII once again, which bars the employment of undocumented persons in all cases, and that insofar as that is an incentive for them to remain continuously resident in the United States as undocumented persons, the government has an interest in removing that incentive. For these reasons, we request this court affirm.
Thank you, Mr. Van Ness. Mr. Baldacci, Mr. Engel, I forgot who's going to argue. Fine. Mr. Engel, you may approach the lectern. What about this compelling governmental interest of respect to the law? Tell us what's wrong with the analysis that we heard from Mr. Van Ness in that regard, and Ms. Olson.
Certainly, Your Honor. The compelling analysis which the respondents pose is that of upholding public safety through encouraging respect for the rule of law. However, this is not only irrational, but inconsistent with the facts we find in our record. As we find on page 4, paragraph 3 of the facts of the record, that undocumented persons who attend college are highly unlikely to end up on jail or on public assistance. Indeed, it's always been—
What about just the respect of the law? And the argument that your colleagues have made is that that is a compelling state interest. Why are they wrong when they say that?
Your Honor, this court in the case of Weber versus Aetna Casualty Insurance Corporation, as cited in Plyler, stated that it is fundamentally unjust, as well as an ineffective means of deterring the parent to punish the child for the sins of the parent. And it's not going to uphold respect for the rule of law to punish people like Miss ARH for crimes which they did not commit. Miss ARH is not responsible for her undocumented status. She was brought
She
here—
is responsible for some misdemeanors, which is keeping her out of DACA.
Certainly, Your Honor. But as my co-counsel already articulated, these factors would never have discluded her from inclusion in college had she not first been an undocumented person, a status she has no control over.
But isn't there sort of a second-level causation problem? In other words, if you want us to accept the argument that a child should not be held responsible for the sins of the parent, doesn't that just encourage more parents to come to America, bring their kids with them, understanding that they're ultimately going to get a free education because the Supreme Court has established a rule that says you're immune?
No, Your Honor, and that addresses the respondent's second government interest, and that of deterring illegal immigration. This court in the case of Plyler versus Doe found that denying children of primary education does not deter legal immigration. And if that's the case, it's highly unlikely that people would come here to give their children a very expensive college education. And there's simply no facts in the record to substantiate this assumption. Addressing the second point of our rebuttal, the free exercise claim. The respondents contend that the decision in Smith was in fact consistent with precedent. But as Justice O'Connor outlined in her concurrence, this is a mischaracterization of the court's precedent in the fact that the court in all of these cases relied expressly on the free exercise clause when granting the compelling interest test. For the respondents to contend that we must present a hybrid rights claim to trigger strict scrutiny is not only inconsistent with the original intent of this Constitution, but places the only appropriate area for free exercise as an albatross around the petitioner's neck, which cannot be the intent of the First Amendment of our Constitution. And given the fact that this law unconstitutionally impinges on Kadesh College's free exercise rights and Miss ARH's right to equal protection, while serving no compelling interest, we ask this court to hold the law unfair, unjust, and ultimately un-American. Thank you.
Thank you very much. The cause will be submitted. Professor Ringel, what do you want us to do, sir?
Okay, I think a round of applause for the